The super profits tax is doomed to end in tears. Even if the government is returned and they try to enact it, it will end in a serious legal and constitutional defeat. The government made a serious error and committed a breach, really, of constitutional propriety in not tabling the report in Parliament and in not having the sort of consultation and debate you normally have before the government responded. Putting it into a media lock-up, putting the opposition there, releasing the government's response simultaneously, was too clever by half. So was breaching the independence of the public service and conscripting the head of Treasury to campaign for the tax. In any event, the government is saying that it's doing this because the minerals belong to all the people of Australia, which is code for saying that they're to be run by the government of Australia. That's wrong. These are matters for state governments. The minerals are vested, as we say, in the Crown, but it's the Crown in the right of Western Australia, the Crown in the right of Queensland or South Australia, whatever state where the minerals are located. And this, of course, is an important principle. The American founding fathers long ago realized that if states don't have their independent sources of income, then they will eventually not be accountable to the people who elect them, and as with healthy adults who are on welfare, the quality of governance will decline. They will become dysfunctional, and that's what's happened in Australia, where the most centralised federation, financially speaking, in the world. The states get less than 20% of their income from their own taxes, and they spend about 40% of the public revenue of the country, the public income of the country. So there's a significant imbalance there, which is being made worse, first by attempting to take back some of the GST, and now moving into an area which is essentially the states. It's for the states to determine what price should be paid in terms of royalties for extracting those minerals, not for the federal parliament. And the Constitution comes in aid in this regard. The Constitution says that the Commonwealth shall not tax the property of the states. And there's a further problem. This tax looks very much like an expropriation, a nationalisation of 40% of the minerals. The federal government is saying this. They're saying they'll be in partnership with the miners. Had they released the report in advance, they would have realised that the public is not going to accept the situation where the Commonwealth government hands over billions of dollars at some stage in the future to cover the losses of some foreign investor, particularly a foreign investor owned by a foreign government. But that said, this is certainly an acquisition of 40%. And what does the Constitution say about this? It says the Commonwealth can only acquire property for the purposes of the Commonwealth. Well, state minerals are not the purposes of the Commonwealth. And secondly, the Constitution says that an acquisition has to be on just terms. And unlike the model on which this super profits tax is based, where the Commonwealth would actually acquire, pay for the 40%, the federal government is not going to pay in advance for this 40%. What just terms are those? No doubt the Commonwealth's lawyers will try to draft the legislation to avoid these aspects of the Constitution. There's every chance that the High Court will look through those. They could get over this by a referendum asking the people to hand over these powers, state powers, to the Commonwealth. I wonder whether the people would agree to that. And even if they did, there's another problem. And that is, under international treaties successive governments have entered into, the rights of foreign investors are protected in Australia. The foreign investors can always call on international arbitrators for orders, awards against the Commonwealth to pay them compensation, which is, in international law terms, prompt, adequate and effective. The Australian government, that is, the Australian taxpayers and taxpayers of successive generations, could be liable for damages running into many, many billions of dollars, perhaps more than the gigantic debt that the Commonwealth is building up at the moment. It would be unlikely that a federal government could pay such damages, and what might happen is an alternative award for restitution, for return of the property that the Commonwealth had taken from the overseas investors. It is also grim, and it's also unnecessary. There's no question of a compromise. The solution is to withdraw this ill-thought-out tax and to leave the matter to the states where the Constitution says it belongs.